Imagine this. A really critical piece of national law, maybe something regulating all medicines, gets pushed into action by the very top office, but without the actual nuts and bolts needed to make it work. What happens then? When good intentions maybe lead to, well, potentially chaos for a country's health.
Yeah.
Today, we're taking an in-depth look into a landmark South African legal case. Pharmaceutical Manufacturers Association of South Africa via the President of the Republic of South Africa. It's quite a story. A presidential decision, a big mistake, and how the highest court had to step in and, really define what public power means in a constitutional democracy.
And what's so fascinating, I think, is how this one case, which seems to be just about drugs and regulations, became this absolutely pivotal moment. It helped define constitutional governance, judicial review, everything in post-apartheid South Africa.
Right.
It's really essential stuff if you're interested in how laws get made, how they're supposed to work, and crucially, how they're held accountable.
Right. So our mission today is to unpack the key legal issues, the arguments people made, what the court decided and why, and maybe most importantly, the lasting impact this case has had on executive power. Okay, let's dive in. So, to set the scene, what exactly was this case all about? What was the law trying to do?
Okay, so at its core, the case was about the South African Medicines and Medical Devices Regulatory Authority Act. Act 132 of 1998. Let's just call it the Act to keep it simple. This law was pretty ambitious. It was meant to completely redo how medicines for people and animals were regulated. It repealed most of the old 1965 Medicines Act and tweaked some other laws too.
And what was the key mechanism in this new system?
Right. The Act brought in this new system of schedules. These are basically lists, detailed lists of regulated substances.
Okay.
Think of them as the absolute foundation. They define what counts as a medicine, how it can be made, sold, possessed. Without the schedules, the whole regulatory system just stops. It's completely inert.
Like taking the engine out of the car.
Exactly that. And the Act said the Minister of Health was supposed to create these new schedules based on recommendations from a new regulatory body that also needed setting up.
Okay, so the Act passes, it sketches out this new system, but the actual schedules aren't made yet. What happened next that kind of lit the fuse?
This is where the critical mistake happened. The president issued something called Proclamation R49 of 1999, and this proclamation said, right, this new act is now in force, fully effective. But the huge problem was that when he did that, those essential new schedules and some other vital regulations, they just hadn't been finalized. They didn't exist yet.
Cool.
And to make matters worse, the proclamation also specifically repealed the old schedules, the ones from the 1965 Act.
Oh, wow. So hang on, if the new schedules weren't ready and the old ones were deliberately canceled, what did that mean on the ground? Like for real people?
Well, the sources paint a pretty alarming picture. Dr. Pretorius, who was the acting Director General of Health then, he put in a sworn statement, an affidavit, and he said the entire regulatory structure relating to medicines has been rendered unworkable, completely broken.
Unworkable.
He warned explicitly that without any schedules, potentially dangerous substances would have become unregulated, just completely uncontrolled.
You mean things that were previously controlled suddenly weren't?
Exactly. Imagine the chaos. Pharmacies wouldn't know what they could legally sell. Doctors may be unsure about prescriptions. And he raised the very real fear that, quote, drug peddlers, pushers, and users would exploit the opportunity.
Gosh.
He even said the danger to South Africa as a whole can hardly be overemphasized. It sounds like a genuine public health emergency waiting to happen.
And did the affidavit say anything about the president's awareness?
Yes. Interestingly, it also revealed the president himself apparently would not have exercised his discretion had he been aware of the administrative flaws. So it points to a mistake, a serious oversight.
Okay, so faced with this unfolding disaster, this regulatory black hole, where do they go? Who took it to court?
Well, interestingly, the president himself, along with other applicants like the Pharmaceutical Manufacturers Association, they actually went to the high court first.
The president sued himself, essentially,
Yeah.
to undo his own proclamation.
In effect, yes. They asked the court to set aside their own proclamation and notice because of the massive problems it created.
What did the high court say?
The first judge, Fabricius A.J., actually dismissed the application.
Really? Why?
His view was basically that the president had the power to issue the proclamation, he acted in good faith, and getting incorrect advice or being a bit premature wasn't enough reason to overturn it.
So the high court basically said, well, he meant well, even if it caused a huge problem. That seems insufficient. Were the pharmaceutical companies okay with that?
Not at all. They appealed. After a few procedural steps, they got permission to take it to the full bench of the same High Court, the Transvaal High Court.
Panels of judges this time.
Right. And the full bench completely reversed the first judge's decision. They declared Proclamation R49 null and void, invalid.
Okay, and their reasoning.
Yeah.
How do they differ from the first judge?
Their reasoning was absolutely key. They made a really important distinction between powers the Constitution gives directly and powers that Parliament delegates to someone, like the president.
Oh, yeah.
They said this power, the power to decide when an act comes into force, wasn't a direct constitutional power in this case. It was a power Parliament had delegated to the president.
And that matters because?
Because delegated powers have limits. You have to use them strictly according to how Parliament intended. The full bench said Parliament couldn't possibly have intended the president to switch on the act before it was actually ready to function, before the schedules were in place.
So he jumped the gun, legally speaking.
That's exactly their finding. They said he acted prematurely and without yet having the authority to do so. And crucially, they also said his good faith, whether he meant well or not, was quite irrelevant to whether the action was legally valid.
That's a big deal. Directly contradicting the first judge.
A very significant finding, yes.
So the full bench strikes down the president's proclamation. But when you're talking about invalidating an act of the president, does the story just end there? Especially in South Africa's system.
No, absolutely not. And this is where it gets even more constitutionally significant. The full bench's order didn't automatically take effect. It had to go up to the Constitutional Court.
Not as an appeal, though.
Not exactly an appeal in the traditional sense. It was because of a specific constitutional rule, Section 172(2)(a).
Okay.
This section basically mandates that any court order that questions the constitutional validity of, well, an act of parliament, a provincial act, or, crucially here, any conduct of the president. That order has no power, no force, unless the Constitutional Court confirms it.
So the big question for the Constitutional Court was, did the full bench ruling saying the president acted unlawfully count as a constitutional matter, needing their stamp of approval? And if yes, should they approve it?
Precisely. And this sparked a really important legal debate at the time. Was the full bench finding that the president acted unlawfully a finding under the old common law rules, or was it inherently a constitutional finding?
Why did that distinction matter so much?
Well, the applicants, perhaps hoping to avoid the Constitutional Court's final say, argued it could just be seen as a common law issue, based on older cases. If it was just common law, maybe the CC confirmation wasn't strictly needed.
So they were suggesting there were sort of two parallel tracks of law, common law review, and constitutional review. What did the Constitutional Court make of that idea?
This is probably the single most important part of the whole judgment. It had huge implications. The Constitutional Court, led by President Chaskelson, was absolutely clear.
What did they say?
They stated definitively, there are not two systems of law. There is only one system of law. It is shaped by the Constitution, which is the supreme law, and all law, including the common law, derives its force from the Constitution and is subject to constitutional control.
Wow. One system under the Constitution.
Exactly. They explained that those old common law principles for reviewing public power, things like acting ultra vires, beyond your powers, they weren't separate anymore. They are now subsumed under the Constitution.
So integrated.
Yes, intertwined. They get their legal force from the Constitution. The Constitution didn't just create new rules. It took the valid parts of the old common law review and embedded them within the new constitutional framework.
That's a fundamental shift. What does it mean practically for challenging government actions?
It means the Constitution explicitly rejects the old system of parliamentary supremacy, where Parliament's laws were basically unquestionable. Instead, it incorporates these review principles and gives them greater substance.
So if a government official acts unlawfully, say, exceeds their power,
it's not just a common law wrong anymore. It's invalid under the Constitution according to the doctrine of legality. This means any review of any public power exercise is now, by definition, a constitutional matter. It closed the door on that two systems argument.
And why was it so crucial for the Constitutional Court to make this crystal clear? What was really at stake?
Because the Constitutional Court is explicitly named the highest court in all constitutional matters and the ultimate guardian of our Constitution.
Right.
Section 167 gives it the final say on what counts as a constitutional matter. If you could argue that reviewing the president's actions was just a common law thing, you could potentially sidestep the Constitutional Court's vital oversight role.
Ah, I see. It would create a loophole.
Exactly. A loophole to shield the highest office from ultimate constitutional scrutiny. The court shut that down firmly, saying any conduct of the president falls under their confirmation jurisdiction. It ensures everyone, right up to the top, is accountable under the Constitution.
Okay, so the jurisdiction question is settled. This is a constitutional matter, and the Constitutional Court must review it. Now, how did they look at the president's actual decision? The first judge said good faith was okay. What was the CC's standard?
They acknowledged the old common law position, referencing cases like Shediac, where acting in good faith, bona fide, often was enough for exercising discretion. But, they stressed, South Africa's new constitutional order demands much more. The country moved consciously from an arbitrary and unequal past towards a constitutional state. And in this new state, government action must be such that it is capable of being analyzed and justified rationally.
Rationally.
Yes. Arbitrariness, they said, just doesn't fit. It's dissonant with the whole idea of the new constitutional setup, which is based on reason, justification, and the rule of law.
So it's not enough for the president to just think he's doing the right thing or to mean well?
Precisely not. The rule of law, which is a core constitutional value, demands that exercising public power should not be arbitrary. Decisions have to be rationally related to the purpose for which the power was given.
Okay, rationally related to the purpose.
This introduces the standard of objective rationality. It's not about the decision-maker's subjective belief. It's about whether the decision, viewed objectively, actually makes sense in relation to the goal it's supposed to achieve.
So good intentions don't save an objectively irrational decision.
Exactly. Good faith is not a defense against objective irrationality. The court was clear. Letting an objectively irrational decision stand just because someone mistakenly thought it was rational would place form above substance and really undermine this key constitutional principle.
Okay, so how did this tougher objective rationality test apply to the president actually proclaiming the act without the schedules being ready?
The court found it failed, quite spectacularly. They said bringing the act into force without the necessary schedules and regulatory framework cannot be found to be objectively rational on any basis whatsoever.
Pretty strong language.
Very. And they pointed straight back to Dr. Pretorius's affidavit, the one describing the unworkable system, the serious consequences, the potential chaos. That evidence powerfully demonstrated the irrationality.
So even though the president acted mistakenly in good faith,
the decision itself, viewed objectively, was completely disconnected from the purpose of the power, which was surely to implement a working system of medicine regulation, not to create chaos. It manifestly failed the objective rationality test.
So what's the big takeaway then from this objective rationality standard? How does it constrain government?
The key takeaway is that rationality is now a minimum threshold requirement for all public power used by the executive branch and other officials.
A minimum threshold.
Yes. Courts won't just jump in and substitute their own opinions on policy. That's not their job. But they absolutely have the power and the duty to step in if a decision is objectively irrational.
Even if it's rare.
The court itself noted that objectively irrational decisions are probably rare. Most decisions, even if maybe unwise, would likely pass this minimum test. But if one is made, the courts must invalidate it.
And the fact the president himself came to court saying, oops, big mistake, this is unworkable, must have really hammered the point home.
Absolutely. It just underscored the clear irrationality of the original proclamation and showed why judicial oversight based on this objective standard is so necessary.
So at the end of the day, the Constitutional Court agreed with the full bench. They confirmed the order, meaning Proclamation R49 was definitely invalid.
Correct. The new act never legally came into force at that point, and crucially, the old 1965 Act was never legally repealed. That confirmation averted the regulatory disaster.
Looking back, what's the lasting significance of this Pharmaceutical Manufacturers Association case? Why do we still talk about it?
Oh, its significance is huge, really. Firstly, it cemented the supremacy of the Constitution as the absolute highest law in South Africa. It explicitly threw out the old idea of parliamentary supremacy. That was fundamental.
A clear break from the past legal order.
A very clear break. And secondly, as we've discussed, it fundamentally reshaped judicial review.
Right. It settled that debate about common law versus constitutional review.
Absolutely. It clarified definitively that all exercises of public power, right up to the president's actions, are subject to review under the Constitution's doctrine of legality. Common law principles now work through the Constitution.
And it gave us that key standard.
Objective rationality. It powerfully established that as a fundamental constitutional limit on government action.
Yeah.
It ensures power isn't used arbitrarily, even if the person using it means well. It's just a bedrock case for administrative and constitutional law in South Africa. Still vital today.
So this deep dive really shows how a single legal case, starting from what seems like a technical administrative error, albeit a massive one, can lead to these really profound clarifications of constitutional principles. It's such a clear example of the shift away from a system where discretion wasn't always deeply scrutinized to a constitutional democracy where all public power has to be justified, has to be rational.
It really does. It cemented that every single act of public power has to be objectively rational. It actually has to work towards its intended goal, not just be well-intentioned. And that's not just abstract legal stuff. It's about making government accountable.
It highlights the court's role as the ultimate guardians of the Constitution, doesn't it?
Yeah.
Making sure even the highest offices stick to the rules.
Exactly. Reinforcing the rule of law for everyone.
So what does this mean for you listening? Well, this case really drives home that understanding these core legal ideas, like the doctrine of legality, objective rationality, it's not just for lawyers. It's kind of a shortcut to understanding how democratic governance is supposed to work, how accountability functions.
Yeah, it shows how even seemingly small bureaucratic slip-ups can spark these huge legal moments that fundamentally reshape how a country is governed, hopefully pushing it towards being more accountable.
So connecting this to the bigger picture, maybe a final thought to leave you with.
Yeah.
In today's world, with laws changing fast and government being so complex, it raises a question, doesn't it? How vigilant do governments, and maybe we as citizens too, need to be to make sure that good policy intentions always line up with the kind of objective rationality the Constitution demands? How do we stop these critical errors from happening again?
That is a really powerful thought. How do we bridge that gap between intention and rational execution consistently?
Something to ponder.
Thank you
For joining us on this deep dive.